wouldn't rule against him or find him guilty was a black woman. So the DA, who had just lost his first 8 cases, who's foaming at the mouth to win, is like, okay, we're gonna try the case, I'll lower the charges, and boom, let's go. So in the process of retrying the case, the prosecutor uses all of his peremptory challenges to strike all the black jurors. They end up with an all-right jury. Mr. Batson is convicted. He's sentenced to prison for 20 years. That was in 1982. As you can see, this is a 1986 case. And in that time, before it reaches the Supreme Court, he spent 4 years in prison. Within the context of the argument his counsel made in the appeal process was that in using those peremptory challenges to target black jurors, that violated Mr. Batson's equal protection rights. Even though peremptory is supposed to be for any reason I want, you still can't use that discretion to violate the equal protection of due process clause of the United States Constitution. Now, in the process of working the case up on the state level, he's in Kentucky. When he reached the Kentucky Supreme Court, they applied the Alabama case, Swain versus Alabama, which says, hey, I mean, you made a good showing here and now that maybe they abused this peremptory power against Mr. Batson here, but you haven't met this overarching systemic pattern of racism beyond this case. So from there, it was sent up on a writ of certiorari, and it reaches the United States Supreme Court. Y'all hanging with me on that?
Yeah.
All right, okay, all right. And just to look at a few key points from the holding in Batson. The first one, so twofold here. For one, they upheld the notion basically that a juror's race can't be the sole basis for using a peremptory strike against them. Also, the inference that if the juror is black and the defendant is black, then the juror is incapable of rendering a true and complete verdict against a black person who's on trial. So if you hear anything of that nature in your practice, that's a challenge. Okay, number 2, the second point that they made. At this point, it's a lot of verbiage there, but basically they overturned that systemic prong or criteria that Swain versus Alabama created, so that you don't have to go and show what's happening all over the country or all over the jurisdiction or in the span of time right here in this particular jurisdiction. You can just focus on what's happening to your client right here, right now, in the use of power. And then lastly, it created the test and the burden shifting formula that is Batson and how it's actually applied, which is the party objecting to the peremptory strikes has to make a prima facie showing that these peremptory strikes are being made on a baseless and racist basis, and then that shifts the burden to the party who made the peremptory challenge for them to show, no, it wasn't about race. There's some other race-neutral justification for me using my peremptories to strike 5 black jurors, right? And then from that point, the court hears and weighs both sides to come back with a decision whether or not we need to go forward with the selections that have been made, or whether or not we need to impanel a new group of potential jurors. So in Texas, I told you I got more case law in. Batson doesn't only apply to the criminal context. It applies in the civil world as well. I don't know the name. Well, Texas Powers versus Palacios here in Texas would be the case. On a federal level, I'm not sure, but I know here in Texas, this is the case. So Batson also applies in a civil context. The prosecution can make Batson challenges. They're not just one-sided anymore. It's not just I'm a black defendant, I'm the only person that can make a Batson challenge. I feel like it's a very equitable concept that everyone should be protected by, whether or not the person is black, white, particular gender, sexual orientation. As we see, it's been expanded, but it's just about fairness. Third, it does apply to gender, it does apply to national origin. In Texas, it does not apply to age, and it does not apply to sexuality or religion, which within our political spectrum of what's happening right now, these things might change. Again, the law's alive and well, and we're the ones who, give it its experience. And then, as I mentioned, anyone can make Batson challenges, be it black, white, whatever. You feel as though race is being weaponized in the peremptory strike process, you can embrace this challenge. The mechanics of Batson. So when you use it, I touched on it earlier. Again, once you went through one iron, you went with your side, y'all evaluated notes, now you're going back before the judge, all huddled up, and say, hey, this person's juror 13, and he looked at me, and he haven't anybody here. Okay, blah, 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 okay, and then you'll say, I want to raise a Batson challenge, and then go into why you feel as though your challenge is valid under Batson. Mechanics of how it works. Touched on it again, but just following highlighted sections. The challenging party is going to make a prima facie showing of racial discrimination to raise an inference of discriminatory intent, and we have to be creative in how we do that. You might resort back to Alabama, where hey, I'm going into a county. I was in Lee County, I got locked up. The judge told me I smirked at him. So if I have another case in Lee County, I might invest into someone to help me do a little research on Lee County before I get down there, and the judge is like, hey, you smirking at me again? And I'm like, nah, judge, I think that peremptory challenge was a little bit discriminatory in nature. But you have to be able to show that. Step two, the party who's been challenged, now they have the burden, and they have to provide, again, a race-neutral explanation for the strike. The explanation does not need to be persuasive or plausible, but it must be clear, reasonably specific, and based on something other than the juror's race. So I don't even know how much sense this case makes, this ruling makes, but that's what it says.
It's a joke.
Put your thinking cap on and let's put together the best argument that we can for our clients. Lastly, the third step, the court must determine whether or not the challenging party has proven racial discrimination, and they can do this by evaluating whether or not there's been an implausible or fantastic justification that is being used as a pretext for real discrimination. And the court can consider all relevant circumstances, including how that challenged party has struck and uses peremptory and for-cause challenges against other potential jurors. So if they're using one basis on a peremptory level to strike everyone in a discriminatory manner, but then they turn a blind eye to that same set of considerations for someone that they're saying, I want that person to be on my as a part of my jury, then I believe that could be a solid way of proving that they're being disingenuous and using pretext to actually try to be discriminatory. And again, the consequence of finding that there's been abuse of peremptories would be to either impanel a whole new group of potential jurors or to just retry. So tips, in terms of some of the things I saw that could be potential ways a party could try to wiggle in unlawful peremptory challenges and try to justify them by basically saying that so basically saying I'm not racist, it's just my intuition that this person is worthy of being struck on a peremptory basis. And then, based on shared race. So that was the point I was making earlier. The potential juror is Asian American, the defendant is Asian American, and it's just my intuition that an Asian juror won't be able to rule fairly when they have to potentially rule against a person of their same ethnicity. Secondly, saying, "Oh, I'm not being racist. I don't have a discriminatory motive. I'm using good faith. Good faith, and I'm just doing the best I can. You know what I mean? Maybe you are doing the best you can. Maybe that's the best you can do. Maybe you're being racist as well. So if they try to make that, well, I'm doing the best I can. Well, let's do a little bit better than you. In Texas, this is a tidbit. Misdemeanors, we have 3 peremptory strikes per panel. 9 capital felonies, there are 10 peremptory, and then in the capital felony arena, this party has 15 peremptory challenges. In closing, just a few remarks here. Never forget that our cases, and these cases that we read about, where we have a last name versus the federal government versus the state. These are people. This was someone's life. In this case, this man was sentenced to 20 years in prison. In the Strouder case, he was sentenced to die. He was sentenced to death, execution. So I just want to say these gentlemen named Taylor Strouder, Robert Swain, James Batson, and many other black folks who weren't going. Second point in closing is that we all love this country.
Take your time.
And we're appreciative. And we're appreciative of all the opportunities we have here, but not to take things for granted. In that this is Black History Month, being mindful that the economy that we have was based upon unpaid and forced labor of African American and Native American people, as well as the rights and privileges and the opportunities we all can enjoy come from a foundation and a legacy of fighting, of people standing up and demanding not only to have fair representation of them within the jury box, but also to participate in the jury box themselves. Not only being defendants, but wanting to exercise a role within the system and the country that we've done so much for. And then lastly, Mr. Batson's case. This is a 1986 case. I'm getting older. I'm 34. I'm 35 this year. Just started growing beard a little bit. This case only happened a few years before I was born, and when we look back over time, I mean, just looking at Strouder, that was almost 100 years before this case. So we haven't reached the goal yet. We still have a lot of work to do, but let's celebrate the progress we've made, and let's all get back out there and try to make things a little bit better. Thank you for your time here.
I just want to say, great job.
Thank you.
Yeah.
Well, our last speaker is not going to make it, so we're going to take this time. Let's just have an open conversation. I do want to thank you all. I mean, we're set to end at 1:30. So if anybody has any questions or would like to add anything, we would like to leave that opportunity to do so. One thing I want to ask before we leave off this Batson subject. Does anybody here know how to actually make a Batson challenge?
I won one.
Cheer. Okay. A jury consultant. He works a lot with our members and with events. And so,
I'm a cheater. Yes.
You are.
So I actually won one a few months ago.
Well, awesome. That's amazing. And thank you for doing this. The important thing about the Batson challenge, when I was on the judicial selection committee for the Houston Lawyers Association, one of the questions that we always ask the judges is, do you know how a Batson challenge is to be granted or denied? And a lot of judges didn't even know what it was, and that was very amazing. But the important thing was they left those interviews with that curiosity, and I can promise you that those judges, we made the better judges, the ones that ended up on the bench, just for asking that question. So it's important that we go and challenge ourselves and take that time to learn how to do a Batson challenge, because it applies to not only African Americans, but even if you're in a case with only white individuals, they have a right to have an African American to be on that jury and be a part of that jury as well. So it's a very important point that
That's
we
my case.
put that
That's what I'm saying.
tool in our toolbox and use it whenever it's
Point,
necessary. Another thing I want to add before we close is these speakers today, they were amazing and they were handpicked for a reason. We don't get a lot of opportunities to put this on our resumes, that to present on our resumes. A lot of organizations, a lot of opportunities are overlooked when it comes to certain individuals. So I want to thank HTLA for giving us this opportunity as well, because our resumes, as far as our presentations, matter with going forward as well. So I want to thank HTLA for that. Raj, thank you so much for allowing this.
I have one more announcement about our Skilly next week.
Okay.
So next week we have our 2-day Skilly program. Robert will actually be there as one of the faculty. Mike Doyle and we've been this our 5th year putting this on. So it starts on Friday afternoon. He brings in speakers from around the nation, but it's just the main focus is how to talk to your jurors, how to talk to your clients, how to prepare your clients. We're bringing in active communication. They have participated over the past years. Usually just 2 of them will come in, but they have worked with some of our members' clients to help them before they take a deposition, or just, the deal, some people talk about dealing with their injuries and things like that. We're bringing in their entire team this time. So on day 2, the workshops where you break out into very small groups and you can bring a case that you're working on, talk to them about it. We're not going to actually have anybody bring their clients, but you can definitely bring your case. And share some of the issues with the actors, and they can work with you on maybe dealing with that issue. But we still have a few openings. It's an incredible program. I talked to a few folks that aren't HTLA members, and if you join, that program will be free to you. So thank y'all.
Thank you. So, do we have any issues we want to bring? I know a lot of this is thought provoking. A lot of this people want to share information that they have. If anybody wants to, I know Robert, you want to make.
I can give a tip about doing Batson challenges. I'll be quick. So here's the thing. Take your shot, okay? A lot of people don't make Batson challenges because, first of all, they think that you're calling the other side racist. And some of the time, some of the lawyers themselves take it that way. But don't worry about that. It's not. Don't worry about their feelings, okay? If someone's striking all the black people or Hispanic people or Asian or whatever it is, take your shot and make the challenge. And a lot of people don't do that because they say, well, they can just come up with any pretext, which is partly true. But sometimes if you'll take your shot, it'll back them off of something else. But take really good notes. And so the reason I say take really good notes is one of the ways that we won our Batson challenge was because when they were giving their pretext, they were saying, well, this person is a psychologist, and I don't want someone on the jury that's trying to get into our client's head. Well, judge, they left somebody who's a school psychologist on the jury. Okay, so that's a pretext. It didn't bother them because the only difference is they're white, right? So those are the ones I lost. But you keep making the arguments on those, and then we finally get to the third one, and they said, well, Judge, she can't see. She's blind. And I said, Judge, listen, you put her in the jury box and had her look at the displays. We know that's not true. And oh, by the way, the reason he's giving as a reason to strike her is a discriminatory reason. He wants to strike her based on her disability. To which the judge responded, Mr. Swafford, do you have any authority for that? Well, Judge, no. The logic's still the same. But regardless, he said it made it clear there's a pretext. And the judge ceded in one of the things you can do is instead of getting rid of the whole array, you can seat somebody who they're trying to strike. And so they put her on the jury. And the jury came back with a $20 million verdict. I'm not saying it's because of the Batson challenge, but I don't think it hurt.
It matters.
Yeah, so, and I was representing a white law enforcement officer from East Texas who had been fired, who was almost certainly full for MAGA, all right? But it's not about, it wasn't about my client, it was about that juror's right to be able to participate fully in society, even if she has a disability, even if the color of her skin didn't match up with what the lawyers on the other side want to say. So, but I want to say thank you so much for the review. Okay,
Thank you.
I really appreciate that.
Yes, it actually, I had the opportunity to use it for sexuality, actually. I had a client who was a lesbian woman, and I made, it was more of a strike for cause. So just because you can't use it for sexuality, you can still help and support a strike for cause. But because she was a lesbian woman, I asked the question, and juror stood up and said, I can't, my Bible says I can't, so, I will be biased towards this person. And we were able to get them off the jury quite easily. So these things are very important. And it goes across the bounds of all type of demographics. So I guess the point here is going back to where it started and where it grew from. And so that case that you talked about, Terry, I think that Judge Conner talked about as well, I looked at the text, and it didn't say black men. It said all white men, which means it's a difference because we're going back to color. That means it wasn't just excluding black men, it was excluding all men of color. And that's what we have to remember. The black men fought, but it affected all the men of color. So that's the part of the honoring what the history has done. So again, thank you all for coming. I really appreciate you all for allowing us to do this for the first, hopefully, of many African American, what is it called? Black history. Black history. Black history celebration. Thank you all.
Okay, so you're gonna use your text your stuff, right? Okay, yeah, okay.
Correct.
Yeah, very impressive.
Sure. I mean, this is all from the beginning. Like, is there any program that y'all are already working with? Or is this all from the beginning? So what kind of,
We're just two businessmen.
what is y'all's company? What do y'all do? You said public speaking?
Well, We have like service-based businesses.
Okay.
Like we're just what we want to do is we want to give back
To the community, right. But
But I know that we have to start.
Well, I would say one is figuring out who you want to start with, right? Like what target group you want to start with. Okay, so probably male. I was gonna say probably starting, from either middle school or high school areas or whatever, right? And then, you want to
I just wanted to say hello, and I enjoyed your presentation. So when I started as a young lawyer, I worked for an African American legal partner. Okay. And we did a lot of cases in Harris County, but we also did cases all over the state. And one of the things that he did in Fort he couldn't say, in Beaumont, like where you did a whole lot. So he would say, at the very end of his order, he would say, when I was in elementary school, I was bullied. And I had, and he talked about this bullying thing, and he said, the kid who bullied me, his name was, I think he used John James. And he said, anybody whose name is John James, or even looks like John James, I have a bias against that person. Yes. And then he'd say, am I anybody's John?
There you go. That's a good one.
Isn't that a good one?
That is a good one.
And
I like that one.
I liked it. And, because it could work for a female.
Absolutely.
Anything.
Oh,
is it raining?
Time for you to get you ready to go.
It started, but I appreciated that.
Yes,
because I experienced it with him.
You have to try to pull it out, yes, in different
because
ways.
he couldn't say it anywhere. In some of these jurisdictions.
Yeah.
Where we were,
Well, that's the thing. It's like, no, again, if you're in there and everybody's sitting there, and then you're like, but we're not going to judge you, and they're like, yeah, right. Yeah,
exactly.
You're going to judge me, the hell out of me when I'm right in front of you.
Right.
So.
And some people may not even have realized, but when they said that, oh yeah. Well, I didn't mean to interrupt. I just wanted to add to your thank you. I really liked that, and
It's now we're at a point, and then when you first start out, it's like you're just so you're trying to prove yourself so much. The older you get in the law, you're like, let me be more intentional about even the whole thing. How do people feel when they walk into I deal with it now on the bench when I have counsel who don't speak to each other. I used to talk to my opposing counsel all the time. You know what I'm saying? And so there's something that's missing now. And it's this adversarial approach to everything.
no matter what.
And it's no matter what. And I'm like, wait, y'all haven't talked. Like, yeah, why are y'all here and y'all haven't even talked? I mean, that's part of your job as a lawyer too. Right? And so, yeah, it's a big deal.
It is, and I had when I was in law school in moot court, I'm very fair-skinned, and when I get nervous, I get kind of splotchy. And so one of my instructors was like, "Oh, you always have to wear a turtleneck."
The turtleneck, right.
And the other one was like, "No,
You embrace it.
Right.
You actually can tell people, hey, I may look like a tomato right now.
Right. When I get nervous,
there's that. You get nervous too. I get nervous.
And I make sure, all this splotchy. And so
it's much more like we're so much more in an environment, and I hope this never changes, that we accept even ourselves more. I think about when I grew up and all of the different images that were put in front of me. This image for beauty, this was for smart, and if you can be just comfortable in your own skin,
absolutely.
to me that's when we've actually arrived. You know what I mean?
Right, and because when you're comfortable in your own skin, then you portray that to others, that you feel good about yourself, and I think it's really important.
And that means that means when I have jurors and I have not just the women but the males too, I ask them who has little children, because if 5 o'clock comes, do you need to be gone?
Right.
And so then I'm like, okay, look, we're gonna end every day. I make that promise with you because I know there's people in here who are taking care of their parents, they're taking care of their kids, some that ride a bus,
Have class to go to.
Yeah, we stayed longer for a jury one time, and it was 8 o'clock, and I didn't realize it was a bus driver. And so he had missed his bus, but he had stayed anyway. Of course, they wanted to be done with the case, but he had stayed, And so I got him an Uber to go home. I think, it's just things that, you can very easily say, I don't care, you're going to stay here until 8, go figure out your way home or whatever. But it's being more, intentional and more aware.
And when you talked about wearing stockings, the first law firm I worked at, I had to wear a skirt and heels and stockings, and I couldn't
Women,
wear
it was awful.
a pantsuit.
Yeah. We had to wear all kinds of stuff. Yeah.
Okay, all right. Thank you.
I enjoyed the
All right, well,
presentation.
good.
a lot.
Thank you.
Sherry Chandler.
Dexter Simmons.
Nice.
Nice to meet you.
Oh yeah, so just what, you can give me just email me, but I'm available this week coming up, so just send me an email or call. Okay?
I got Washington, so.
Yeah. Oh, absolutely. Yes. Who is it?
The president of Houston.
Oh, perfect. Okay. Look. No, this is it. So let's yeah. I'll get time. Okay, that's fine. I'll get with you and you can set up with me. Sorry.
This is cool.
Look. This is why I don't do stuff. This is why I honey.
Oh man, that was.
You will find
Yeah.
that I get a lot of yes.
That was.
Okay. So no, guess what? I will help you.
So I'm just looking for resources, recommendations,
Give me your
things like
information.
that. Yes,
We
ma'am.
have to talk. We'll have to set up a
Yes,
meeting
ma'am.
too.
So what we can do is just set up something to where me and my partner, my business partner, we all three.
Yes,
We're just looking for. We just want to be active. You know what I'm saying?
I love it. And there's so many.
In the biggest and best possible way. You know?
Okay, so let me give you my number and then.
I used to play football.
Oh, okay. What kind? In college or?
High school, and then I graduated from Boise State.
Okay.
Buffalo.
Where'd y'all go to high school?
I went to Spring Westfield.
Spring Westfield. Okay.
I went to Langham Creek with him for a little bit.
Oh, okay.
For a little
Langham
bit.
Creek and Spring Westfield. Okay. All right. So here, my number is 281-709-5412. Okay, and then just put Judge Evans, and then text me, and we can set up a Zoom this week too. Okay? Let's do it.
It's
I
nice
love
to
it.
meet you.
It's nice meeting you too. I'm from here. I'm from Houston.
What high school you?
I went to Bel Air,
LA, okay.
but I was on to Sterling. Okay. And then I went to undergrad in New Orleans. I went to Loyola.
Okay.
And then I came back and went to Thurgood. So I went to Thurgood with Unica, with UA. I don't know where she is. Yeah. So that's how I know her.
I'm gonna contact you.
Okay,
all right?
you absolutely.
Nice to meet you.
It's nice meeting you.
what's up? What's up? Oh, okay.
Jeremy might know some different groups of people, you know what I'm saying? You know, everybody is and stuff like that.
Okay, yeah, definitely.
He went to Westfield, he ended up coming to Langley. He went to Langley.
Yeah, I'm from out here, third dude. I went to OT. Okay. Yeah, I went to San East yeah, same.
My brother, said he was coach at Rice.
Oh, okay. You look like you. No, okay. Hey, You did, bro.
I'm prepared. I ain't want to put it in
I feel like it was a spider web. I like it. Someone watched it. One spider watched it.
liked it? Yeah, thought it was interesting?
Yeah.
Was it too boring?
No, it wasn't too boring.
It's pretty inspiring to hear the stories.
Yeah?
Their point of view. Their point of view on it.
Yeah. I like Jen Collier. She did really good. She did a really good job.
I'm going to invite you in here to go to the game. We're about to end that week. We're going to take you to the pro shop. Get you something else because you know that environment and you'll be like, oh my God. You just get
My battery had died during the thing I set it to the side.
She walks in, I go, oh, let me introduce you to the DJ. And she goes, oh my God.
He's my client.
Oh, okay.
Talk to me about that dog on house. Everything he doing.